Good afternoon. This is definitely going to become one of the more cozy panels of this conference. We already understood the challenge of a latest or last session on a Friday afternoon on the one hand, and then being in competition with a big session on cyber surveillance. So our thanks go to those who are the dieharders of the topic on cross-border data flows in the financial industry. I have the privilege of chairing this session, and one of my key tasks is to make sure that you understand who is on this panel and what we're going to do. My name is Erik Valgaeren, and I'm a partner at Stibbe, an international law firm where I head up the technology and data protection practice. Another key role on this panel is the moderator. For that, I'm assisted by Hee-Eun Kim, to my left. She is a legal counsel at Samsung Electronics. Obviously not an unknown player, a very large group, also very much a data-rich company itself. She's been there since September of last year, I understood, and she was a member of the Brussels Bar before that, practicing at Covington and Burling in international trade and cartel competition law matters. She's also been involved in WIPO and the UN. On top of her Korean law degree, she has obtained many postgraduates as well. Very international legal profile with King's College, Munich, IP, Stanford Law. So very happy to have her as a moderator this afternoon. To her left, we are in excellent company with Dr. Park. Dr. Park, who is a professor of law at Korea University, where he's also the director. This is Jan-Willem Verheijden. We have to the left of course, thank you, Jan-Willem, to the left of Hee-Eun. Jan-Willem Verheijden, who is with the European Commission since 2011, and where he's now a member of DG Trade, where he's a trade negotiator. We will hear more about that in a moment. He has a law degree from Erasmus University in Rotterdam, and was also a part of the Erasmus project, where he was taken to Paris to study law there as well. To his left, we then have our notorious Dr. Park, whom, as I said, is a professor of law at Korea University, also director of Cyber Law Center there. He has obviously not just graduated there from Korea University, but also has a postgraduate from Harvard and a PhD from Cambridge. I'm not going to recite his extensive list of publications, but he's an international authority on e-commerce, competition law, WTO issues, and many other related trade topics. Then to the left of Professor Park, we have Steve Wood. Steve Wood is with the UK Information Commissioner's Office, where he is the head of policy delivery. This afternoon, I'm sure that Steve will deliver as well on this panel, because he actually has a background in IT, as I understand it, Steve, where you have taken up many roles in international companies doing IT consultancy work, and you've been a lecturer as well, as I understood it, on IT management at John Moores University in Liverpool. Then last but not least, we have Dervish Tayyip, who is with Microsoft since 2006, where he has now recently been promoted to the Assistant General Counsel position, so very much involved in all the legal and policy aspects of data protection. Before joining Microsoft, Dervish was a solicitor and a partner at the firm Reed Minty, and he obviously has studied law in the UK with his law degree from Queen Mary's and a postgraduate from University of College London. So that being said, we will kick off with our storyline on what we're going to do this afternoon. We have short presentations by each member of the panel. We have focused on about 12 minutes so that we have some time for discussion between the panelists with members of the audience. The topic is the cross-border data flows in the financial industry. We will first actually hear from Jan-Willem as to what the perspective is from an EU side on the context of international trade, the trade agreements and the impact and relationship they have with data flows. Then we will have Professor Park explore the aspect of data flows in the financial industry from a Korean perspective, looking in particular at the trade agreements Korea has with the EU on the one hand and with the US on the other hand. We will then have Steve joining with the DPA's views on what is happening in cross-border data flows in the financial sector, and we will then hear from Dervish as to what is happening in the industry, because obviously Microsoft is a vendor, but they're also committed to listening to their clients and understanding their concerns, so he will share some of that with us. So without further delay, I happily give the floor to Jan-Willem.
Thank you very much, Erik. I would like to make a small correction to my bio. I've been slightly longer at the European Commission, but that's since 2005. That's just a minor comment. Well, thank you very much first for the invitation by Korea University. I would like to say something on the trade perspective of data flows. I work for DG Trade of the European Commission. We consider data flows to be extremely important for global trade. It's particularly important in highly data-intensive industries such as financial services and related IT services. It's important for cost efficiency reasons, but it's of course very important for companies that they can put all relevant data together in headquarters or regional hubs and create synergies in order to improve internal processes. That is why in all the EU free trade agreements we have included provisions on free data flows for financial services suppliers. So that this has been done in the free trade agreement between the EU and Korea, the ones that have been concluded with Colombia, Peru, the one with Canada, the CETA agreement, and is also subject of negotiations in current free trade draft agreements, such as the one with the US, the Transatlantic Trade and Investment Partnership, TTIP, and the Trade and Services Agreement. So this is a basic element of our free trade agreements. What exactly do we have on free flow of information in our trade agreements? There is a basic rule saying that financial service suppliers must have the possibility to transfer data outside the territory of a trading partner. In the case of Korea, we then also have additional commitments of both parties that outsourcing that banks should be able to outsource certain functions and such as accounting services, IT, data processing services, a number of services, and all these services typically they require data transfers as well. What I must say, however, is that we do not deal with data protection in free trade agreements. As you know, data protection is a fundamental right. Therefore, we do not think this can be part of a trade agreement. We do not negotiate a fundamental right. We negotiate other things in trade agreements. We don't touch on substantial rules on data protection in trade agreements. So we have a general rule on data flows. and that is also subject to very strong safeguards and exceptions on data protection. So in particular, some of you may be familiar with that, Article 14 of the GATS, the General Agreement on Trade and Services. So that is the WTO agreement on trade and services. It already has a rule on, there is a so-called understanding on data transfer in the financial sector. But in the GATS agreement itself, there's also a very strong exception for data protection. So irrespective of all the trade rules in the WTO on trade and services, and in particular those on data flows, all parties to that agreement have the right to take any measures that are necessary for personal data protection. And in addition, I should mention that the EU has a practice also to include in its trade agreements, in particular the one between the EU and Korea, a commitment to ensure adequate levels of data protection. So there's no specific rules on substance, but there is a general rule also that data protection should be adequate in the territory of the parties to the agreement. So how has this worked out in practice until now? Generally, the feedback we get from our companies is that this is really a key part of trade agreements, works very well, allows them to do business to a certain extent. But we also have some issues. For instance, in the FTA between EU and Korea, EU businesses are very concerned that in reality they face a lot of obstacles when they want to move data from Korea to headquarters in Europe or to other regional hubs. So we have been discussing this with the Korean authorities. A lot of progress has been made. There has been a reform of the Korean procedure for IT, for allowing IT outsourcing in the financial sector. Nevertheless, there are still issues out there, as in particular the length of the procedure. So officially there's a 3-month period for deciding on an approval for IT outsourcing in the financial sector. But that's the official procedure, but there is a pre-application procedure. So in order to be eligible to apply for an IT outsourcing approval, there's a prior procedure which takes a very long time, and there's a very limited number of European companies that have received approval for outsourcing IT activities and for transferring data out of Korea. Another issue is legal certainty. So there's a number. The application of this data transfer principle is very detailed and is experienced as very cumbersome by several European companies, and we have raised this with the Korean authorities. There has been a meeting actually 2 days ago with a new announcement by Korea that they will now completely revise their procedure for allowing IT outsourcing by foreign companies. So that is a very positive signal, and so we are hopeful that this will, and we are confident that this will improve in Korea, and this is certainly an issue that we will also be raising in other trade agreements. Thank you.
Mary? Thank you. First, I'd like to introduce my center, Cyber Law Center at Korea University. It was established in 2012, aiming at rule of law in cyberspace and focusing on data privacy and cybersecurity in particular. And also, we are trying to contribute to Asian voice making. So, you see the picture. It was taken last year. We have been in cooperation with Keio University in Tokyo to organize so-called Asia Forum on Cybersecurity and Privacy. Now, as the previous speaker explained, Korea has undertaken commitments under the FTAs with EU and US, respectively, to revise its regulatory regime to allow financial institutions located in Korea to transfer information to affiliates outside Korea and to allow certain data processing and other functions to be performed in affiliates outside Korea. According to its commitments under the FTAs, Korea has revised its regulatory regime for cross-border flow of information in financial services. And the two FTAs have given Korea 2 years after the entry into force of the FTAs for the commitments of the cross-border flow of information in financial services, and the provisions in Korea EU FTA and Korea US FTA on the cross-border flow of data or information is identical. First, the assessment of, especially from the US, according to the Congressional Research Service, industry representatives have referred to the services-related provisions of the Korea-US FTA as the gold standard for the treatment of services, particularly financial services in FTAs. And also, according to the USTR, they say, for the first time in any trade agreement, the Korea-US FTA contains in the financial services a specific reference to data transfer, enabling US companies to freely transfer customer data into and out of a partner country. I'd like to explain some provisions, especially under the Korea-EU FTA. Under the FTA, financial services include provision and transfer of financial information and financial data processing. And also each party shall permit transfer of information in electronic or other form for data processing in the ordinary course of business of such financial service suppliers. And also each party should adopt adequate safeguards to the protection of privacy with regard to the transfer of personal data. And Korea has the additional commitment. Korea will permit the transfer of financial information across borders while addressing protection of sensitive information of consumers, prohibitions on unauthorized reuse of the sensitive information, the ability of financial regulators to have access to records of financial service suppliers. And there is some exceptions, such as nothing in this chapter under the FTA is construed to prevent the adoption or enforcement by either party of measures relating to such as protection of the privacy in relation to the processing and dissemination of personal data and the protection of confidentiality of individual records and accounts. So Korea has revised its regime in order to implement the provisions of the FTAs. For example, the Financial Services Commission is very powerful, the government dealing with financial matters. The Commission adopted regulations on financial institutions, outsourcing of data processing business and IT facilities in 2013. But this regulation in nature is merely a notification. It is not at the level of law or regulation. And also the guide, or interpreting some provisions of the Korean regulation was adopted in 2013, and also another manual was adopted. I'd like to explain briefly what the regime provides. First, a financial institution is permitted to outsource data processing to a third party, domestic or overseas. In case a financial institution intends to outsource data processing overseas, only its head office, branches, or affiliates are permitted to do so. And the outsourced company is allowed only with the approval of the governor or financial supervisor service to re-outsource. And the procedure, financial institutions are mandated to apply standard firm contract. It is already provided in the Korean regulation. And also, such a financial institution should report the governor before it concludes such outsourcing agreement. And also, regarding IT facilities, a financial institution is permitted with the approval from the Financial Services Commission to outsource IT facilities to its overseas head office, branches, and affiliates. And FSC may restrict such overseas outsourcing of IT facilities. And supervision and inspection by the Financial Services Commission and Financial Supervisory Service. Assessment of the Korea-EU FTA, I think there might have been some compromise in the negotiations of the Korea-EU, Korea-US FTA, such as between financial services, including data processing overseas, and other areas under the FTA, and also between financial services, including data processing overseas, and safeguards for privacy and personal data. And I have some difficulty in reading and understanding the provisions of the FTA and also the provisions of Korean regulation, because there are some, difficulty with the definition of the concept, such as what is finance information, what is sensitive information. They are not defined. And also the Korean regulation mainly focuses on outsourcing. Outsourcing is, in Korean law, a special kind of contract. And also the Korean regulation prohibits the transfer of unique identification data, and also some restrictions on the sensitive information flow outside. And again, in Korean regulation, we have some difficulty in defining those important concepts like unique identification data and also sensitive information. And the practical difficulty with the transfer of information in finance services is the role of supervisory authorities in Korea. As I mentioned several times, there are two institutions, one Financial Services Commission and another Financial Supervisory Service. And they have the same or similar authority for different size for the cross-border transfer of data. But the previous speaker explained that recently Korea adopts a kind of simplified the way for the application of the cross-border data flow. And finally, as a conclusion, I think cross-border transfer of information for data processing and finance services on the Korea-EU FTA, Korea-US FTA is very important, because it may innovatively expand financial services to the benefit of financial service customers as well as financial service suppliers. It is also certain to contribute to advancement of digital economy globally, and it is a leading initiative for international data transfer as to affect other sectors. However, for cross-border transfer of information, financial transaction of consumers for trade secrets and personal data to be protected, should be protected, and also effective supervision of the authorities for consumers and financial services should be allowed. And finally, objective and effective rules, international rules and national rules should be developed and observed. Thank you.
Thank you very much. I'm going to give the perspective from a European Data Protection Authority. So I'm based at the UK Information Commissioner's Office. The first thing I'd say by way of opening is obviously financial data is data which individuals regard as very important to them. So misuse of financial data or the loss of financial data can have severe impacts on individuals. Therefore, there are obviously some important risks that have to be addressed when financial data is transferred, particularly outside of the European Union. Financial services as well, I think, are very aware as well, I think, of the customer trust issue and the importance of customers understanding how safe their data is, and I think increasingly as well making sure customers understand in a transparent way how their data is used and moved around the globe. There's still a lot of work to be done in that area, but I think there is a realization of the importance of transparency in this area, and I think it's becoming an important feature with data protection generally in the commercial sector, but hopefully we're starting to move towards the position where privacy may be seen as a market differentiator in the way that companies can sell their customer service offering. In terms of focusing on the area of financial services from the perspective of a data protection authority and the transfer of personal data to third countries outside the EU, there isn't one model which is prescribed by data protection authority like the ICO. Financial services are very complex in terms of the types of interactions and the different ways that data will have to flow. So there may be a need to transfer data within the actual multinational group, so an intra-group transfer. So data may need to transfer from one part of the group in one country to another part of the group in another country. There also may be need to transfer the data from one company to an entirely different company. So there may be need to transfer data from one data controller to another data controller. There may be a need to transfer data from a data controller to a data processor in an outsourcing relationship. So there's very much a responsibility on a financial services company in terms of data protection law to very much assess data protection law requirements in terms of international transfers in the context of their own business. So they've really got to audit the flows of data, understand and map the data controller, data processor relationships, and the different types of safeguards which may need to be put in place. So thinking about the structure of the European directive, which is the starting point for the ICO, obviously Article 25 of the Data Protection Directive talks about an adequate level of protection being able to be provided in terms of data protection law in a third country. And then Article 26 talks about derogations from that. So even where a country is not regarded as adequate in terms of its data protection law on the European basis, there's still a possibility for a data controller to essentially provide, to adduce certain safeguards which can then be authorized, and therefore data can still actually flow to that data controller based outside the EU on the basis of the safeguards they've actually provided. So there are many different options for financial services companies in terms of how they may wish to provide those safeguards. But two of the most well-known and the most well-used safeguards are either the use of model contractual clauses, so they're published by the European Commission and then can be filled out and completed in the context of the particular data transfers which need to take place, or there's the concept of binding corporate rules. So one question we're often asked by companies is what is the best option for them? Should they be seeking to use contractual clauses in terms of governing and providing the right safeguards in terms of the transfer of data, or should they be using binding corporate rules? Well, there's not one correct answer really in terms of saying for financial services what the right model is. And often, because of the various complex scenarios that I outlined earlier, it may often be that often a mix of binding corporate rules and contractual clauses were needed to be put in place to gather, to cover the various different data flows. The benefits of binding corporate rules are particularly its flexibility in that it can actually cover all of the intra-group transfers. It can also really be set out as a way of really raising the profile of data protection across the entire multinational group. So it actually has a focus on areas such as audit and training, etc., and it can be a very good way of demonstrating a company's commitment to data protection. It can have a broad scope and it can have more flexibility. Contractual clauses would tend to be focused on specific scenarios. One thing about the binding corporate rules process is that it can actually take quite a long time in terms of the complexity of taking that through the application process. So it can take up to a year for a binding corporate rules application to be approved by the home data protection authority in terms of the lead data protection authority in terms of the European process. Certainly at the ICO, we've seen a range of interest in binding corporate rules, and since the process was launched, the current process within Europe, we've now actually authorized over 20 binding corporate rules applications from essentially multinational companies. Within that group, there have been a number of companies from the financial services industry who've applied, such as Citibank, American Express, etc. So binding corporate rules are seen as a valuable option for the financial services industry. The other development I want to talk about briefly is the work which has been taking place globally, thinking beyond the work on binding corporate rules at European level, which is work which has been taking place between the Article 29 Working Party at European level and the group of economies in the Asia-Pacific area under the guise of APEC, in terms of mapping the European binding corporate rules, the BCR system, against the system that APEC uses for international transfers, the CBPR, so that's the cross-border privacy rules which APEC set out. So work has taken place to actually develop what we would call a referential. So it's not a mutual recognition system, but really a checklist has been developed to enable companies who may want to actually apply for essentially dual certification. So they may wish to actually apply for binding corporate rules in terms of the European context, but also to get CBPR certification in the Asia-Pacific context. The checklist which has been developed through work with the Article 29 Working Party and APEC allows companies to actually see the benefits of both systems. And what the referential does, if you haven't looked at it, it's quite a handy document, but it sets out all of the common elements, so the things which are the same between both systems, and then also draws out the areas where both BCR and CBPR have different elements. But there are some common elements between the two in terms of enforcements, in terms of how responsibilities flow with the data, around transparency requirements, access, rectification, audit and redress. However, the European system has more detail detail in it in terms of certain requirements which aren't in the Asia Pacific requirements. So there's more detail and more requirements in the European law, but that obviously reflects the standard of data protection that we wish to have in the European Data Protection Directive. So I'd say that the work in mapping BCRs and CBPRs will be of benefit and of use to financial services organisations over time, and it's really probably the first step in the right direction and moving to a more sort of global interoperable system for international transfers. And I'll leave it there for now.
Thank you. Can you move the slides along? Good afternoon, everyone. Just as we get the slides that I'm going to use up, my vantage point working at Microsoft has been, as to this topic, has been from a cloud, enterprise cloud, a business-to-business cloud perspective, and our ability as a cloud service provider to enable international data flows generally, clearly something that is fundamental to the success of cloud computing, but also the specifically for the financial services sector. If you, I have it here. Great, thank you. So there are two dimensions at which we come at this topic. One is clearly a need to work within the existing regulatory regime. That's the immediate need. If we're going to be able to have cloud services in the marketplace today, we need to comply with the current regulatory landscape, clearly. The other is that, and I'll spend just a little bit at the end talking about this, that we think, in fact, in terms of what would be the ideal model moving forward, the model perhaps ought to be a different one than the current approach in the directive, and an approach that seemingly is going to continue under the regulation of this more sort of narrow and intense focus, as it currently is, on data location and a restriction on export of that data towards a model that should in fact focus on accountability, on transparency, as already has been touched upon, and security, so that frankly where your data sits is no longer of any relevance. It's whether it is secure, it is you're providing transparency to the data controller as to what is happening with the data and data subjects to, and as I say, accountability. On the first aspect of that, which is that on the point of having to comply with the current regulatory landscape, if you want to have your services in the marketplace, we have done a fair amount of work at Microsoft. I think we're leading on this, specifically working with the regulators. And so we decided that the way we were going to make enterprise cloud services available in Europe was to go talk to the regulators and to adopt one of the existing processes for international data flows, namely the standard contractual clauses, otherwise known as model clauses. And we did that, the need to engage with the regulators clear, because the clauses as a mechanism were clearly created before cloud computing and mass flows of data across borders was a reality. We engaged with a long story short, but we engaged with the regulators, told them how we thought model clauses should be applied in the context of business-to-business cloud computing services, specifically to the financial sector, but more broadly. And we worked through that process such that we, first of all, from individual data protection authorities around Europe, were able to obtain public confirmation that they were satisfied with the way we were implementing model clauses. And then if you, I can now move the slides along myself, can I? And then you may know that in April of last year, the Article 29 Working Party, made up of all the regulators, data protection regulators in the EU or EEA, were very public in their assertion that, as you can see from the slide, publicly produced correspondence that verified that our implementation was indeed sufficient for our customers to be satisfied that that they would be complying with European data protection law on the flow of data outside of the EU, to the extent that there is flow of data outside the EU. The other set of regulators we've engaged with is financial services regulators specifically. And again, you may be aware that we've done some work with a global consortium of those regulators, which at the time was led by the Dutch regulator, the Dutch National Bank, in order to satisfy them that some of the concerns the financial services regulators had about cloud computing, fundamentally which was about their ability to continue to supervise their regulated entities. For example, how would you effect an audit or a right to inspect, as they refer to it, within a cloud computing context? Again, we worked with the regulators and found solutions that satisfied them. And so both on the data protection side and on the financial services side, we've been leading the way in terms of trying to work within the existing regulatory landscape. And we believe we are in both cases, we've been the first large cloud computing provider to find those solutions. But as I said earlier, that's the existing regulatory landscape. I think we are clear that that's not for us the ideal model. And I think I indicated earlier why that is, because in a dynamic where the data is flowing across borders all of the time, frankly, the focus should be less. If you look back at to why we have the export restriction in the Data Protection Directive, the underlying reasons, it's fundamentally to stop unauthorized access to the data. Yes, there's use that comes next, but frankly, if unauthorized access is not enabled, then use is a secondary question. And we think that in order to achieve that, there are actually other more appropriate mechanisms for achieving that underlying goal. And the fact that the data sits in any particular location geographically is not fundamental to that question. And so one of the, take data encryption as an example. If you have strong encryption for data crossing borders, and there is effective management of the decryption process and keys, then frankly, as I say, where the data sits is neither here nor there. The fact is the data would be secure. So we have set ourselves the task of best-in-class encryption across the entire communication stages that you see reflected in this slide. And that involves moving to, first of all, huge engineering investment in order to enable that, and also the 2048-bit key length encryption. And so once the data is in an unintelligible form, we think that where the data is actually stored, it should not be important. But it's more than that. Transparency is equally important, and again, we've done a fair amount of, through what we call trust centers for the enterprise cloud services, we have been very upfront about providing data maps for the flow of data so that our customers, the data controllers, can see what the flow of data is geographically, which borders the data might be cutting across. We have committed to allowing data at rest to sit within the EU. The customer can be assured that it has the choice, and that is enabled. We have also been very clear about who has access to the data, and also certain restrictions on what subcontractors can do. And again, we've I think led the way there, because as a result of our model clauses discussions with the regulators, it's clear that the regulators needed more than the vendors were doing at the time in order to be compliant. For example, one of the things we were required to do revolves around giving our customers the ability, should we appoint a subcontractor to one of our cloud computing services that they disapprove of, for whatever reason. First of all, we are required to give the data controller at a minimum of 14 days notice of the appointment of that subcontractor, and then the customer, the data controller, has the ability to come off the service without any penalty. And so again, it retains a greater degree of control than was the case previously. The final point I'll make is on transparency is that we also have been very clear on the contractual commitments we will make regarding third-party access to data, particularly law enforcement. You'll see what we commit to on this slide, and it is a commitment. These are contractual terms. These aren't some hazy, woolly language contained in marketing material. The case you may be aware of at the moment that is pretty high profile is the one that's running through the courts in New York and is at the appeal stage. And is another example of how vendors are able to take some action. So it's not just contractual language, but actually act on that language. And the case I'm referring to involves US law enforcement reaching into data sitting in the European Union in Dublin and seeking to obtain that data without going through the necessary mutual legal assistance treaties. And Microsoft is the first vendor to stand up to that and say, no, that's not right. You cannot do that with physical data. You should not be able to do it with digital information. And we are in the course of litigating that with the US authorities. And the outcome, I think, of that decision will have huge ramifications for the industry and sector. My final point, and I apologize if I'm a couple of minutes over, there is another very important aspect to all of this, and that's security. And the other, so first of all, you obviously have to build your services with security from the ground up. But we do more than that. We actually have a sector, a digital crimes unit and a cybercrime center that goes out and proactively fights botnets and other such crimes. Meaning what? That these are PCs that are infected with malware, that have had their security breached, and we are able to identify what the IP addresses of those PCs are, and we will go notify, first of all, we will take the botnet down, working with law enforcement. We will notify those of our customers who have those IP addresses so they can clean up, and we will help them clean up the malware. And we will feed the intelligence that we have gathered in that way back into our own services. I think it's a unique example in the industry. And we actually work with, for the financial services sector, we have a partnership with the Financial Services Information Sharing and Analysis Center, FCISAC, which is where the banks share physical and cyber intelligence between them, threats between them. And we do what I just described for them. For members of that organization, we will provide them with intelligence that we pick up when we take these botnets down at free of charge, and they will be able to have awareness of the malware, of distributed denial of service attacks, and financial botnet attacks on them. I'll stop there. Thank you.
Okay, thank you. So I think we started with a very interesting example of the particular issues in the context of the Korea-EU Free Trade Agreement. And then we nicely moved to the more broader context of international data transfer rules and then privacy and security rules generally in the financial sector, foreseeing new technological development. Before I open up questions, does any of the panel or the chair have any remarks on each other's presentation? No? Okay. Okay, and the chair, do you have any comments?
If asked, I always have a comment, of course. Being a lawyer in private practice is part of what we do. No, I think we presented an interesting line of succession in the way this unfolds. I do have a question, and the question is, where should the international framework really head to in terms of creating some kind of level playing field for the financial sector in dealing with border data flows, because obviously we had this big achievement with the initial directive within the European Union, but we're just one small corner of the world. I understand Korea has free trade agreements in place with 2 significant blocks of economic trading partners. We are still looking at the negotiations with the US in terms of free trade agreement, but there again, you know, it's going to be just one other block of the world. What should be the way forward in creating a level playing field? Because I think if I was listening to also both Steve and Dervish, if it's about creating the trust and the transparency and the security, you know, shouldn't we be doing more there to create that level playing field? Sorry for the long question, but I would be happy to have your comment.
Is this on? Yeah. Well, I mean, you've observed fundamentally the argument that I was trying to make, that that the issue should not be geographic. It's not export out of and into another geography. If you look at the underlying reasons why what we're trying to achieve, then the level playing field that you talk about should, I would argue, focus on, regardless of whichever part of the world you're in, on accountability, on transparency and security. And working on those principles around the world, we ought to be able to get to a far greater level playing field than we have today.
Just to pick up on that, and I'll happily have also Steve's views on it, the problem I'm facing is that you rightly underscore the need for, you know, getting rid of location and geography. It's just that the legal rules are still structured on the basis of, you know, jurisdictions and countries and all. So considering the limited kind of availability of adequacy recognitions and all, you know, what should we be doing to kind of breach those walls and barriers? But maybe Steve has a view on that as well. And I'm sure that the European Commission representative will have, even if he's not speaking on behalf of them. So Jan-Willem, I think you're up next.
I mean, I think in reality, we're always, in this area, we're always going to be dealing with different countries and different areas which have different laws. Therefore, it's really always going to have to be a step-by-step approach, I think, to trying to gain this greater international recognition of the standards we can all support. And obviously in Europe, we have a particular standard that we want to focus on in terms of the Data Protection Directive. But I think the work that we have done with APEC in the Asia-Pacific region to show that we can start to make those steps to actually recognise that there are similarities in fundamental areas which we do have in common. I think the other thing we'll have to make a decision on at European level is what we regard as acceptable when we're thinking about adequacy. Is it an absolute cast iron matching of the standards we have in our European Data Protection Directive, or are we prepared to be flexible to have something which we would agree is compatible with European data protection law? But I think there's often debate about what tests we actually need to have to make sure that we're satisfied at European level, and I think work's going to need to carry on to make sure we've got agreement about that.
Yeah, maybe just to add from the trade angle, you mentioned that Korea has agreements with US and EU. The EU is now negotiating an agreement with the US. At the same time, the EU, Korea and the US and 20 other partners are negotiating in Geneva in the context of the Trade and Services Agreement, where there's also a couple of provisions on the transfer of financial information, and the objective of the participating countries in those in that negotiating agreement is to once that agreement is concluded, to export it to the WTO level, which will not be easy, but the objective is to have then a common agreement on the transfer of financial information shared by more than 100 countries. So that is a bit from the trade angle. I think different partners have an interest in financial information flows, and are seeing how they can also address this multilaterally. While of course, and I should really say this because this is very important from the EU's perspective, safeguarding, making sure that data protection is safeguarded. So obviously I'm talking from a very general angle. So it's about the basic rules that financial information transfer should be allowed. But that also requires then agreement on the substantial rules and on implementation, and there's obviously also much work to be done there.
So I have questions. Dervish, you mentioned your experience of working with the dealing with not only the data protection authorities, but also now financial regulators, as your company is moving into cloud computing for banks, with the banks. So how was your experience of, having dealing with both regulators? How has your experience evolved so far?
It's a very interesting dynamic that we have seen. So when we first started talking to both sets of regulators, 3-4 years ago, it was clear that there really was a need for dialogue on both sides. I think the regulators needed to understand the technology better, and we needed to understand their concerns, any concerns that would arise as they understood the technology better. And and with anything, some of the regulators were more open to having that dialogue, and others less so. And so we obviously spoke to those that would speak to us. And I think the results really speak for themselves, that the regulators that we were able to talk to and were open to the idea of dialogue were able to carry to a large extent the remaining regulators. Now that's not every single one, and that will take time, but I think that, as in anything in life, if you understand the concerns of the other side and you have solutions that meet those concerns, and that's obviously the critical piece, then you can move forward. And the financial services side and the data protection regulators have not necessarily always moved in lockstep together. At different points and different issues, they've been at different parts of the map. But fundamentally, the general direction of travel has been positive in both cases.
Okay, thank you. So now we're going back to the topic of Korea. So Professor Park, I have a question for you. So apart from the implementation issues that you talked about, what are the issues that you have in Korea in terms of data protection? Because we don't, here in Europe, we don't hear much about Korean data protection law issues. So I think it would be good if you could give us a bit of a taste about, how the enforcement landscape is over there.
Yes. Probably many of us know Professor Greenleaf in Australia. He once mentioned that at least in Asia, Korean legal system on data protection is one of the highest and best. But I'm living in Korea and I see our legal system, but there are rivalry between different governments for different data protection system, so that those confusing systems make data subjects confused about how they are well protected in data protection. So that is, I think, one of the biggest problems in Korea. But actually we have, in a sense, very good system of law one basic general law. In addition to that, there are specific areas like data protection online and also the kind of credit information protection. So in a sense, we have a good system, but there are some confusing implementation and the conflicting governmental authorities. There are some problems.
Are there any questions from the audience? Yes, all the way at the back, please.
Thank you. Mimi Kim from Free University of Brussels. I just want to thank you all panelists for your interesting actually presentations. My question concerns actually the financial data flow, specifically for the Korea and EU FTA, as well as Mr. Tayyip's comments about perhaps the data physical location is not actually necessary if it's well encrypted. Now, coming back to Korea-EU FTA, the financial data transfer, as far as I know, the Korea ICT outsourcing regulation stipulates Korean authority must be able to access physically the financial data, which I think was a bit of a concern for the European part. In other words, if you would transfer, let's say, Standard Chartered's data, financial database, to its branch in Singapore, obviously the data will be, as far as I know, transported somewhere in Mumbai or the US for storage. Now, the Korean regulation says the Financial Service Commission should be able to access this data physically. Now, there comes your challenge, for example. I don't know where Korea is the only actually case in having law like this, but I understand the other countries in Asia that are negotiating with the FTA at the moment are looking at the Korean case very carefully here, because the European side says that that clause in particular is very concerning, because it seems like the Korean government wants to give ICT outsourcing jobs to domestic companies. This is their view, because the financial data has been, for example, transferred over a long time and always stored elsewhere, independent of whatever her headquarters are. So I don't know how you see that, and also for the person from the Commission, how this issue was resolved in Korea. Another question I want to raise is I've talked to South Korean banks in terms of their own financial transfer in Europe. Say a Korean bank having a branch in Poland, and it wants to transfer its actually own financial data to its branch in London. Now, they told me that to do that, they have to go through a Polish DPA to get their permission, and then they have to go to London, for example, and they have to bear all the cost to do that. So they don't think actually it is a very transparent and actually easily facilitating procedure we have in Europe. Thank you.
Okay,
Can I go first? I'll leave the question about the processes and that's not my area, but to your question about the requirement, as I understood it under Korean law, that the data be accessible by the regulator, whether it's in hard law, such as the one that I think the example you're giving, or whether it is implied, it is a concern you will hear from all regulators. Now, there are different agendas at play. So if the agenda is jobs in Korea, I'm not in a position to comment on that. But the concern we hear when we talk to regulators is, as I mentioned in my presentation, their ability to supervise. If they cannot get at the data, either because it's encrypted or they physically don't have a right, then you have diluted their when compared with what they can do today, you're diluting their supervisory authority. And that's not what we're about. That's not what cloud computing is trying to do. So there are solutions to this. We have hit upon one, which is to give the regulators a physical right to inspect, effectively to have an audit. And that was the outcome of our engagement with the Dutch National Bank, and that's what all financial regulators have today from Microsoft. And on the, and let me ask you, there are other models that are possible. For example, you could encrypt, but you could have a process, some sort of a model of escrow, where the encryption key, while secure, is there available should the regulator want to get at the data. So it can effectively decrypt. So it's not as though there aren't solutions. I think the challenges are, what are the agendas, and what are we really trying to achieve? That's really the important dynamic.
Yeah. Willem?
Yeah, maybe just to add that from the EU's industry perspective, or from the EU's industry side, there haven't been many complaints specifically about this issue. So I think, well, we have been now a few years in the implementation process of the FTA, EU and Korea. And what we get as feedback from our industry is they are able to transfer data from Korea to the EU. The process is lengthy, and there's a number of issues related to legal clarity. So, for instance, the financial transaction regulation in Korea has requirements on ledgers, which are master databases, but the definition is not clear. So this is not stipulated in the legislation, and the Korean authorities typically have a very broad interpretation of ledgers, whereas industry has a more narrow interpretation. So these are really the issues that European companies in Korea face. Now, more generally about data localization requirements. Okay. Many countries, including Korea and, or I should say trading blocs, Korea and the EU, have taken in the WTO context what we call full commitments in computer services, which implies that you cannot have any discriminatory treatment of computer service. You cannot treat your own computer service providers better than a computer service from another country. If you have local data storage requirements, this can be interpreted as discriminatory treatment of computer services. So there are exceptions that apply, but the main rule is that there cannot be discriminatory treatment of computer services for those parties that have taken commitments, including Korea and the EU. Leave it at that.
Yeah, okay. And Professor Park, maybe he could give us some background. So this law that was the subject of the question, like the requirement of having financial regulators being physically access to financial data. Is there a plan to change this law, or the Korea's intention is to keep it?
No, I don't think so. I think as Dervish mentioned, for the financial services, the government authority for supervision, that should not be reduced or limited, but there should be kind of effectiveness for the data transfer, but the supervision should be there, I think.
And the second question was about this challenges of intra-group financial data transfer, if I understood correctly. Steve, we want to comment on this? Yeah, okay. Any other questions? Probably the last one. Okay, please.
Thank you, Latvian Human Rights Institute. I have a question about principle of data minimization. I didn't hear that anybody of this panel touched this issue, but I think it's quite important also in financial
Sorry,
data flow.
could you repeat the question?
There is a trend, at least in SEPA, that data like personal address and ID number is also transferred to the partner of transaction. Do you think it's reasonable or it's not too much? Because why other party needs to know where do I live? Except that I have IBAN number, which is standard, so it's actually enough. Thank you. And one small comment on the botnets. I think that according to the security firms, most of botnets actually are based on Microsoft's operating system, so maybe it's just a social function to eliminate that, actually, or clean up this stuff. Okay, thanks.
Yeah, who will take the first question? I think it was about the principle of data minimization. Steve, maybe you want to?
No, and we haven't had time to touch on everything today, but I think certainly looking at the concept of ensuring that only the data which is necessary and proportionate for the transaction of it's between two data controllers in terms of perhaps linking of data sets relating to financial services, then that is an important consideration and an important piece of guidance that is always given to data controllers in that situation. So we're going to recognise the importance of data minimization.
And then the second question, I think it should go to Dervish.
I'm not sure I understood the question. So you were commenting about the Microsoft operating system?
In Microsoft Windows, right?
Yes.
It's at least according to University of Latvia's researchers, also some international firms, that most of the botnets are using this system.
Well, so if you deem that as a criticism, the reality is that if you have the majority of PCs using any operating system, then of course most of the issues are going to come out of that operating system simply because of how widely it is used. I think the issue we were trying to raise was not just issues that come out of operating systems. All sorts of various cyber attacks can target various parts of the different layers in the IT infrastructure. So, so I think it is important, one, to put your comment and those other organizations that may be critical of one particular operating system into perspective, and then secondly say, well, and even further, it's only one small part of the overall range of possible security threats that are out there.
Yeah, thank you. So in the interest of time, I think we're gonna close the panel session. Thank you for your time today, and it was a really, really interesting discussion. I hope we can continue next year. Thanks.